The panelists are going to be speaking on the implications of the Harvard and UNC affirmative action cases for workplace DEI initiatives. And our speakers are Brittany Noel Torres from Littler Mendelsohn and Alan Klinger from Strick and Levan. And our co-commentators are Terrence J. Nolan, LLC ADR, and former general counsel of NYU, and Professor Thomas Lee, Fordham School of Law, director of the Fordham Center for Asian Americans and the Law. Take it away, panelists.
Thank you. The last panel, so people have hung in. And of course, the last panel, I should say, as an initial matter, the Harvard and UNC cases have nothing to do with employment. The cases represent challenge to universities' use of race for student admissions. Now, that use is based on Justice Powell's opinion, which he wrote by himself in the Bakke case, where Justice Powell's principal rationale was that he was deferring to the university's position on the pedagogical value of diversity. He wasn't using the term diversity in the sense we've heard it earlier today, that is, to increase representation in professions and in other areas of previously underrepresented groups. Now, Justice Powell's opinion was adopted by the Supreme Court fully 25 years later in the Grutter case. And the often cited rationale for today's diversity, equity, and inclusion efforts, even though it's not a perfect analogy, is a decision by the Supreme Court 45 years ago, Weber against Steelworkers. In that decision, which written by Justice Brennan, and he explicitly said it had nothing to do with the Equal Protection Clause, the court approved a collectively bargained affirmative action plan. That plan provided that half of the new admittees to a craft training program would be African American until the proportion of craft employees equaled those in the workforce as a whole. And of course, African Americans had been historically excluded from those craft positions. Now, the court viewed this as a text versus intent issue, and you heard Professor Sherman earlier today talk about this. The court conceded that the literal wording of Title VII would seem to prohibit this. But the court cited the overall intent of Title VII. And interestingly, the court cited as its authority for this a case from 1892, Holy Trinity Church against the United States. In that case, there was a statute which prohibited employers from contracting with employees overseas to work in the U.S. prior to them coming to the U.S. And in that case, the church had hired an Anglican minister in the UK to come to the U.S., which was a literal violation of the statute. But the court said this wasn't really Congress's intent, and went on for a few paragraphs talking about how this is a Christian nation, and that's not how, this wasn't really the intent. Now, that case has been the Holy Trinity case has been something of a bugaboo to legal textualists. Justice Scalia criticizes it in an essay he wrote, and saying that this emphasis on legislative intent as opposed to the actual text was not proper. Now, several years later, in the late 80s, the Supreme Court decided Johnson against Transportation Agency. And the court approved an affirmative action plan which was designed to increase women as dispatchers in this agency. And there had never before been a woman in the 200-plus positions. Again, the court said the overall intent was that would permit this affirmative action plan. Justice Scalia wrote a scathing dissent. Justice Ginsburg, in her dissent in the Gratz case, which was decided the same day as Grutter, there the University of Michigan's undergraduate affirmative action plan was struck down. But Justice Ginsburg said, the intent is relevant, and taking account of race for purposes of inclusion, does not violate the Equal Protection Clause. And perhaps recognizing this intent versus text issue, Harvard, in its opposition to the cert petition, argued that the same Congress which adopted the 14th Amendment rejected alternative versions of the amendment, which were said to be colorblind, and itself adopted explicitly race-conscious laws. Now, while technically unrelated, if Grutter is overruled, as many commentators are suggesting, are we, among other things, looking at a revival of Section 703J of Title VII, which by its text explicitly provides that nothing in the statute shall be interpreted to require preferential treatment based on remedying racial imbalances in the workforce. In Weber, the court stated that while that may not be required, that doesn't mean it couldn't be permitted in appropriate circumstances, and Weber had those appropriate circumstances, the history of discrimination. Whether today's court would take a similar view is an open question, and it's going to be the subject of our discussion. And Professor Lee, can you give us some of that constitutional background?
Yes, so I'm just going to go over the Grutter case and the analysis of what might happen in Harvard UNC. So the big caveat here, this is all hypothetical. We don't know what the Supreme Court's going to do. I'm going to operate on the presumption that the Supreme Court will hold that student body diversity is not a compelling interest to justify race-based admissions policies at Harvard University and likely the University of North Carolina, and presume that, you know, what does that mean for the employment context? I would say, having listened to the oral arguments carefully, I think most commentators before the fact thought that there wasn't much of a chance that they would not overrule Grutter. For example, they might say that when we mean narrowly tailored, we mean narrowly tailored, and that includes thinking of getting rid of some of these other preferences you have that create a zero-sum game that is something of your own creation. There were a couple of questions, and particularly Justice Gorsuch, that indicated that maybe they'd look for some way out in the middle, preserve Grutter, but say that narrow tailoring, we mean narrow tailoring, and you're not taking it seriously enough. The problem with that, of course, is that it essentially amounts to fact-based error correction. There was a jury trial, strike that, not a jury trial, but a bench trial done to that on these issues. So there's a small likelihood, though. I think before I listened to the oral arguments, I thought that was very unlikely, but perhaps that might happen. So I'm going to presume that Grutter gets overruled so that student body diversity is not a compelling interest to justify race-based admissions policies at highly selective universities. About 20% of the country's colleges and universities apply some form of race-based admission preferences. So the big question I want to sort of set up is, well, what could a potential overruling of Grutter along these lines mean for other contexts? In order to do that, we have to unpack Grutter a little bit. Now, Terry mentioned Justice Powell's opinion in Bakke, and so that is the starting point. So the idea was that in order to have race-based admissions policies, you had to have some sort of forward-looking justification. A backward-looking justification would not work unless absent a particular history of discrimination in that institution. Specific discrimination is backward-looking. So forward-looking, and in an article I wrote many years ago when Grutter came out, I said, well, there's two types of forward-looking rationales that were present in the Grutter case. One is what I call discourse benefits, and this is what Powell was talking about in Bakke. So when you have people from various races and ethnicities and other backgrounds in the university setting, the education you receive is much more, is richer, it's much more various, it's much more, it's consistent with the educational mission of the university. You learn more from a room full of students and colleagues that come from different backgrounds than if you come to a university where everyone's from the same background. So that's what I call the discourse benefits. But it's interesting because, and if it was limited to Justice Powell's reasoning in Bakke, I think that whatever happens in this case would be somewhat more narrowly confined. But that's not exactly what the Supreme Court adopted in Grutter. So the Supreme Court in Grutter adopted, I think, a subtly different type of reasoning, what I call leadership benefits. And so the idea there is the discourse benefits of diversity, student body diversity aside, these institutions are gatekeeping institutions for leadership positions in society, in the economy, in big business. And so in order to ensure leadership diversity in these socially important institutions, we have to have meaningful race and ethnic diversity within the institutions itself. And the reason, and I'm just going to quote a little bit from an amicus brief filed by Carter Phillips of Sidley, which was on behalf of retired generals and admirals that sort of brought this point home. And the point that they made was, well, we need diversity in the officer corps at the selective military academies, and we need diversity in the student bodies at these military academies because we need leadership diversity in our junior officer ranks because we have enlisted ranks that have many minorities, and if they just see white officers, male officers leading them, it's going to be ineffective. It's not going to be an effective military force. And I have to put a caveat here because I'm speaking in my own personal capacity. I'm a member of the Defense Advisory Committee on Diversity and Inclusion in the Armed Forces, so nothing I say has anything to do with my service on that commission. It's just as a constitutional law professor. So it's interesting because the brief continues, and this is a direct quotation from the brief, it requires only a small step from this analysis to conclude that our country's other most selective institutions must remain both diverse and selective. Like our military security, our economic security and international competitiveness depend upon it, right? So this, I think, carried the day in Grutter, this sort of subtly different leadership diversity, forward-looking type of analysis. And if Grutter gets overruled, and if this particular line of reasoning gets rejected, well, then the contextual ramifications for other types of situations also becomes much more significant, is my guess. And it's interesting because when the government briefed this issue, the Department of Defense signed on with the general position. So the Department of Defense could have sort of gone off its own and argued, well, even if you strike down student body diversity at the highly selective universities, you should allow it at the military academies because their reason for wanting diversity is importantly different because they want diversity in the officer corps, and so leadership diversity is something that is distinguishable. It may be the case that, however, the Supreme Court writes the opinion, they'll write that carve-out in, despite the fact that the government didn't argue it. But you could sort of appreciate how, depending on how they overrule Grutter, they could just sort of write it in a way that cabins it to the discourse benefits and say, like, look, we don't believe that the universities have made the case, or we don't necessarily believe that this sort of discourse benefit is sufficient to justify these types of programs at highly selective universities. And at the same time, they sort of have to reject the leadership diversity reasoning. And if they do, then potentially the ramifications are much broader, is my sense from having analyzed Grutter. So that's all I'm going to say, just the constitutional analysis, just breaking down the analysis in Grutter and what a potential overruling of that opinion might mean in terms of the constitutional law.
All right, Ms. Torres, conflation of affirmative action and DEI programs?
Absolutely. So it's a great point of distinction to be made here, especially in trying to predict and prepare for the implications of the pending Supreme Court case. And so my opinion and my experience here is informed by multiple organizations and advising them in terms of their voluntary diversity, equity, and inclusion investments and initiatives. And so on October 31st and November 1st, I had numerous questions, some of them urgent, from clients thinking, after this oral argument, what are the implications? What do we have to do as employers and as organizations in the context of DEI? And the short answer is, well, there is nothing direct and there is nothing immediate. The pending case is not related to Title VII, and we don't even have a final opinion yet. But there is a lot of speculation, a lot of conjecture, numerous op-eds out there immediately about what this might mean for employers. And before we dig into that, first, we do need to distinguish affirmative action from DEI. So when we have affirmative action, that's the requirement to make race-conscious decisions. It only applies in very limited circumstances. There's also the potential for a voluntary affirmative action plan, which any employer could undertake in the interest of diversity, equity, and inclusion. However, there is a very specific legal test and standard which must be met in order to successfully adopt a voluntary affirmative action plan, distinguishing that entirely from a diversity, equity, and inclusion plan, which is not governed in the same way by case law, Supreme Court jurisprudence, and oftentimes, in fact, is agnostic to protected characteristics. It's not based on race at all. Instead, it's meant to apply to everybody to increase the potential for everyone and anyone to reach the levels of leadership within organizations, to see opportunities for advancement, to be graded and rated fairly in performance reviews. So in advising organizations on how to address potentially discrepancies and differences in their workforce demographics as compared to larger population demographics, first we have to think about what level of risk are we interested in undertaking here, and specifically what type of risk. And a lot of times this does come down to a business decision. Are we knowingly taking on the risk of a discrimination claim due to a lack of representation, or are we knowingly undertaking the risk of a diversity, equity, and inclusion initiative or program, which is from the opposite end of the spectrum normally? And we can see that in the rise in quote-unquote reverse discrimination lawsuits. So when it comes to addressing the implications of the pending case, actually not much is changing from what has been my typical advice at the beginning of a conversation with an organization. And that is, do you want to take an approach that is agnostic of protected characteristics, or do you want to take something that takes race, gender, whatever it might be, into account? Typically, the preferred approach is to take the agnostic approach, which would not be implicated. There would be no implications, no direct implications from an affirmative action case. But in implementation of that voluntary DEI initiative or program, there are three very important things to consider. One being the intent. Does the intent of the initiative align with the risk profile that your organization has? And of course, that risk profile is based on the direction that we're seeing in the case law. Second, what is the policy that is actually going to be adopted? The letters that are put on paper that are communicated to employees that are potentially publicly known. And then third is what is actually happening in practice? And that is where we might come closer to the implications of the pending case impacting a DEI program. And that is because when these practices are implemented, when initiatives are undertaken, a lot of times very well-meaning individuals within the organization understand them and internalize them and act upon them more in the lines of an affirmative action program. So the implications of the pending case may have more direct consequences for what those individual managers potentially are doing in the interests of diversity, equity, and inclusion. And more specifically, in terms of litigation, what those individuals are doing, how is it being recorded within the organization, such that there may now be evidence that could be discoverable, that could be used in a trial, to support either a finding of reverse discrimination or that an organization had in practice adopted an affirmative action plan. And we're seeing an increase in the reverse discrimination cases. I always use air quotes there because, as we all know, Title VII protects all races, all genders. So the term reverse isn't actually necessary. Discrimination is discrimination under the law. But it is colloquially how we refer to these types of cases, which are increasing in frequency and certainly in the level of profile and for the potential dollar amounts attached to jury awards related to them. And as a result of the increase in that prevalence, we are seeing further efforts from advocacy groups, whether it's targeting an organization that has very publicly adopted diversity, equity, inclusion initiatives or even aspirational goals, creating complaints in terms of governmental regulation, private litigation. We also have individual plaintiffs, class action discrimination lawsuits, and of course shareholder derivative lawsuits. So all of that litigation is increasing. I would expect that it would continue to increase if anything along the lines of what we're expecting from the pending case actually ends up in the opinions. But there is certainly an interest and a buzz around how DEI may or may not violate anti-discrimination laws. And in the context of those litigations, how the cases are being litigated is also changing. The types of information that are being requested. So whether you have a lawsuit related to anti-discrimination, specifically reverse discrimination, a shareholder derivative lawsuit, what is being sought is the organizational commitment to diversity, equity, and inclusion, including public statements, annual reports, and especially data analytics that a lot of organizations are voluntarily undertaking to decipher where investments are needed and to what extent. And so all of that, organizations need to prepare, especially as these cases continue coming up and having high-profile opinions and decisions, that any of that work that is supporting diversity, equity, and inclusion could be requested within litigation and may be used to argue that a voluntary DEI program actually rose to the level of affirmative action.
Well, Ms. Torres, thank you very much. Mr. Klinger, what's happening out there? What's your view?
So I've been assigned what's happening as a practical matter, and kind of like Professor Lee made his sort of disclosure, I want to say up front that what I'm going to say is happening is not what's happening at Strzok and Levan. Just so we are clear about that. What's happening is, and when we spoke about this in preparation for the panel, Professor Lee turned to me and he said, "That's illegal." And I said, "They don't care." And that's what I wanted to talk about, a little bit here, is that companies, law firms are facing now being told by major clients, particularly financial institutions. So let's just take an example in the law firm context. They're saying, not only do we want to see women and people of color on the transaction team, on the litigation team, we want to see the leaders of the team be of that nature. And whether the DEI concept construct is the morally right thing to do, I would like to think that a lot of organizations would do it for that reason. But when your clients are telling you this is what they expect, require, it is going to up the ante on getting that done. And frankly, that's what I've been seeing in talking to clients, other lawyers, in terms of what's happening, that the model that we heard about and spoke about what DEI is supposed to do, increase the pipeline, go to more schools, go to historically black colleges or universities to recruit. All that is right and appropriate, But I think, frankly, we're kidding ourselves if people think that hiring decisions aren't being made not because of a specific quota, but because of a desire or design to make sure that they have upped the percentage in their workforce. And frankly, and also we talked, at the prior panel, they talked a little bit about, well, there's a difference between hiring, recruiting, and termination or firing. Same factors are being looked at there in terms of who should be let go if you need a reduction in force. And that people are looking and seeing not just if there's a reduction in force, whether to go through the disparate impact analysis that I'm sure you're all familiar with in terms of what will this show. They're also looking to say it is hard enough to recruit to begin with. We're going to put like a thumb on the scale, and I do think that's happening not everywhere, but in a lot of places. And I do think that is something that if the decisions in the academic setting come out the way we anticipate, there's going to be much more pressure on this notion of scrutinizing race-conscious efforts. And it's sort of, there was reference to United Steelworkers versus Weber before. And if you look at that, and when I read it again in preparation for today, 1979 is not all that long ago. At least when you, I don't know. I guess when you're at a certain stage in life. I was in law school, so to me it's not that long ago.
I've been out for 5 years.
But that what influenced the court there was, yes, that it was voluntary, that that was spoken
Yes.
about, that it was remedying sort of a past imbalance in the craft level of the work, that it was to be temporary, though I'd be interested to know how long it took. That I don't know, in terms of having the percentage of the craft be of a racial percentage that mirrored the labor workforce, at that time, and that it wasn't impacting anyone who already was in employ. So, those were the sort of the limiting factors of Weber. Whether we are going to be able to, sort of craft something like that, because I do think that over time, since 1979, I think that there have been a lot of not publicly filed affirmative action plans for federal contracting or things like that. I think there have been internalized affirmative action programs in many companies and law firms throughout the country, and they have not relied upon the limiting factors of Weber to justify their thinking. And if you think, and I think this is part of what Terry was talking about earlier, this is being done not for pernicious reasons. It's not being done because they want to discriminate against white male. They're doing because this was sort of the intent of Title VII when it was drafted, that when you look at the legislative history, it was to make sure, and in those days, Negro was still the term being used, it was that Negroes would be able to get into the workforce in greater numbers than they were, where it was quite limited. And I think that is the spirit of what companies in law firms have been trying to do now. And yes, it certainly runs afoul of what Justice Scalia, wrote about, quite often in terms of look at the words of the statute, not what we are putting a gloss on of the intent. But that is what's happened, and I do think that is something that may change dramatically depending upon how broadly this is written, and I do, that the decision comes out from the United States Supreme Court. And I think what we will be facing, which was, just indicated, could be a wealth of litigation, which could be good for employment lawyers, but that there are going to be challenges. You have things, we have in the materials, I think, the letters to the EEOC for Mars and Starbucks. It's the America First Legal Foundation. They have made this, sort of their cause to be doing this. There are going to be others. There are going to be, we talked about just now the lawsuits being filed for this and what could happen. And I think that we are seeing something that could be a major change to how many organizations have been operating over, certainly the last 10 years and probably longer.
Maybe just one thing we haven't mentioned. In Grutter, Justice O'Connor's 25-year kind of limitation, that, or at least the concept that these programs should be limited in scope, even as there's some reference to that even in far back as Weber.
Yeah, right. So I think some commentators have made a point about that. I mean, obviously, she was sort of pulling it out of her hat, so to speak. I don't put as much confidence in that prediction or say that it has any force. I mean, the one thing I will say, and this is cued both toward Alan and Brittany's comments about DEI, right? So let's assume that Grutter is overruled. So the diversity piece, as I understand it, is about recruitment and let's take, for example, I don't know why it suddenly occurred to me, like NYU Law School. So what is NYU Law School going to do? I mean, presumably, my understanding is that LSDAS will continue to report race demographic data, but they'll have to blind it all and at the admissions office and not deploy them. Now, race-correlated financial aid, that will probably have to stop, or they'll have to figure out some way to get around that. But inclusion, to the extent that inclusion or belonging is the more appropriate word, to the extent that NYU Law or any outfit has measures to make sure that everybody in the community, regardless of their race or ethnicity, feels like they belong, feels like a full-fledged citizen, doesn't get disparaged or doesn't get sort of stereotyped. I mean, I think that's safe, right? The I piece is safe. Equity piece, and I think that in the vocabulary, people are starting to stay away from the equity because the word equity itself, as a civil procedure person, I can appreciate that from a different direction because equity means something totally different, but it sort of has a social justice implication, an overt normativity that is somewhat problematic. So I've heard people talk about equal opportunity. But to the extent that the E piece really is, okay, once the students are here, like let's revisit how the sort of key plums are awarded, like positions on the law review or positions at sort of prestigious firms, associates, clerkships. Like, let's try to figure out a way to make sure that criteria that we've sort of used since time immemorial, that we really think about whether we need this or if it's a needless obstacle. I think that those are probably safe too, right? I mean, as long as you lawyer them and engineer them correctly. And so, from my perspective, let's stop calling E-equity, think about equal opportunity, and be careful and do what we're supposed to do, like lawyer around. The E and I pieces feel much safer to me. But obviously, that D piece, and this is what I was trying to get at with Grutter. I mean, O'Connor and Grutter and Terry, the 25-year time horizon part is a piece of it, but she sort of, I mean, that opinion goes a lot broader than Bakke. I mean, she really does think that we need this at our elite universities because we want leadership diversity in our key institutions, and that is essential to military security. It's essential to economic security. It's essential to all these things. If Grutter goes large and says, we don't buy any of that anymore, then people are going to have to start thinking really hard about that D piece in context very far afield from higher education.
By the way, NYU has had litigation on the selection of the law review editors on that very subject.
So Terry, if I can ask you.
It's over. We won in the Second Circuit.
I mean, this may be stretching, but if I can ask the panel a question for this, is that we understand the argument that was made about the need for the elite universities, which is kind of an elitist argument to begin with. Okay. But do you see that there could be a different argument in the business world about the importance of sort of diversity there? I'm thinking a little bit, not so much about the last panel about customer preference, the prior panel, but do you see that there could be a argument that developed for that is different?
Absolutely. And to tie in the comments about, are there temporal implications for how long a race-conscious program should be in place? I think because of the number of years that have passed and all of the legislative developments and social justice movements that have occurred since that time, we have a presumption that there is less discrimination, that there is better representation. But there was actually a fascinating study published by Northwestern in January of this year that found that across 6 Western countries, from 1969 to 2019, that there actually wasn't much, if any, improvement in terms of discrimination for candidates in the application process. So that's striking, especially when we're considering the implications of the case and how organizations might implement related measures. In that amount of time, with everything that has happened, to think that there hasn't been an increase as a society, an improvement in diversity, equity, or inclusion, or whichever terms you choose to paint that picture within your organization. So as a result of that, organizations, companies that have business relationships have taken upon themselves to be more aggressive in moving that needle forward. And so you do see things like clients saying that their suppliers must have a person of certain identities, or the demographics on their teams must be representative of communities or their organization as a whole, because although a lot of time has passed and there's been a lot of discussion about this, have we actually seen a difference? Are there changes in representation such that the best, most qualified, most skilled talent available is going to be selected for positions, promotions, to lead organizations?
What about, it was Justice Thomas at argument who, went after, the value of diversity as a pedagogical. I mean, I've heard some people argue, that's a difficult argument because you can get an outstanding education at Wellesley College or Yeshiva University or an HBCU, and, they're not diverse.
I think that's a very valid point. And when I wrote about it, I said, look, this is where the First Amendment kicks in. The university that is running the particular enterprise has some discretion as to what they're looking for, right? And obviously, historically, black college or university has chosen to make a different First Amendment choice and wants something different. And I think that at least that part of Grutter, I mean, O'Connor's opinion didn't do a very good job of sort of figuring out the doctrinal analogies, but I think it certainly makes some sense, right? I mean, this sort of aspect of discretion. But broader than that, I mean, what Brittany says is absolutely true. So for the military, why does the military want diversity? Well, because, if the Marine Corps is 21% Latino in the enlisted ranks, but there are no Latino generals, then that is not going to, the military is about fielding the most lethal warfighting force known to humankind, right? And so it's not going to be effective when you have one group of people taking all the orders and another group of people giving all the orders. And so I think one of the things that if Grutter does get overruled, I think different communities, different contexts are going to have to think a lot more carefully and unpack why exactly they want this thing. And I think Justice Thomas was right. I felt sorry for Ryan Park, the advocate, when he really started. I know him. He was a former. But I felt bad for when he really went after him because he didn't have a very good response. But I think that we sort of have to be more careful, more lawyerly, about thinking very carefully about what diversity means for this particular institution and why this institution needs it.
Question? Oh, Commissioner Lipnick, yes.
Hello? There we go. Thank you. So my question relates to Johnson and Weber and the jurisprudence under Johnson and Weber in the employment context. And of course, the language in Johnson and Weber is that you have to show a manifest imbalance, right, in a traditionally segregated job. And I'm just curious, particularly for Ms. Torres and Mr. Klinger, and to be clear, for voluntary affirmative action plans, right? So not in the federal contractor context. So do you have clients who actually want you to demonstrate a manifest imbalance in a traditionally segregated job? And have you helped them create voluntary affirmative action plans, right, specifically on those terms and those criteria from Johnson and Weber? And then my second question related to that is, given that affirmative action, the terms itself, right, can be somewhat toxic. So while you can have the legal justification for a voluntary affirmative action plan for a private company, do you have them, though, shy away from, oh my God, we don't want to call this an affirmative action plan, even though that would give you the legal justification for doing it?
Great question. First, I think that the manifest imbalance prong of the applicable test is point number one in the conversation of, would you like to adopt a voluntary affirmative action plan? Because pretty resoundingly, the answer is absolutely not. We do not want to put together Exhibit A for plaintiff's trial brief. I mean, that is not what we want to do. We do not want to say that any of our past practices have resulted in this manifest imbalance. So absolutely, it's an important point. I think it's best to address it head on and early, because that would be a requirement if you were to actually undertake voluntary affirmative action. Second, in terms of actually adopting a voluntary affirmative action plan, if the organization knowingly understands that they would have to document this manifest imbalance, is there a different way to approach this? And a lot of times there is. When we think about affirmative action or changing the representation of a certain demographic group, if we're thinking of race, gender, any other protected characteristic as the determinative variable, we're often taking too superficial of a review of the concept in general. What is the root cause? What is a facially neutral policy or practice that is actually having a different impact? And can we instead address and correct, maybe change that root cause, as opposed to taking a counteracting affirmative action program under?
And I endorse Brittany's view, in large part because I respect what she brings to this. I will tell you that I think I am one of Sam's favorite directors on the Labor and Employment Center, because I'm the co-managing partner of a Wall Street law firm, management. But most of the work I do is public sector union work, where I overlap with Terry, so I mean, I've had more limited experience, but what I have had is exactly what Brittany said.
Ask one question about the language of manifest imbalance. Why can't you just use the executive order language? We have an availability, we've searched, we've increased our availability, and, you know, under the law, whether you're a federal contractor or not, we've got the guidance of the executive order. We want to approach what our availability is, and not use the words manifest imbalance, or the word affirmative action. The problem I have with the general counsel is directed, it was a short-lived general counsel at Coca-Cola. These numbers were coming out of the air. They were rigid, they came out of the air. So, you know, let the firms report on where people are in the pipeline and urge them to go away. You know, not just hire people, but mentor them so that there's not this enormous turnover in the law firms. And you get a sense of what the availability is before you set these targets. That's what I would argue. By the way, Justice, I did a brief in Grutter, it's pronounced Grutter, actually. Probably is my co-author on my I'm going to defer to him. I did a brief aimed at O'Connor, because I read all of her employment discrimination cases, and that's what she was advocating. What happened in Grutter is she read the Sidley Austin brief, and she thought that the nation's security would be imperiled. So she changed. Basically, what I just said is the EO 11246 standard, which she was advocating for all those cases.
I'll just say that
I got one person to join me from the ranks of O'Connor clerks on that brief, Eugene Bowen.
I would just say that I completely agree with the preference for availability as opposed to manifest imbalance, and in practice, in taking a very data-based approach to determining whether there is an underrepresentation of any specific demographic group, we need to consider availability, and we typically like to do so in an attorney-client privileged work product situation, so that you are not conducting an analysis that could then inadvertently be used, much like a commitment to a manifest imbalance would be used.
And by unprivileged, it's still an open question.
Yes.
Just having lawyers involved, that's the common judgment. It's not clear if that can function as a self-evaluation.
But certainly improves your chances.
Yes.
One more? Does anyone think it'll make a difference, and I'm just throwing this out cold, that Justice Jackson participated in the UNC case, but not in the Harvard case? Any possibility of a split of some sort? No one wants, I don't know, I have no answer.
Yeah. I mean, she's not sort of, I mean, if you bean count and do the Kremlinology, she's not a difference maker, so it shouldn't make a difference. The one thing that I thought was very interesting about the UNC case, and sort of the Asian American angle, I mean, those of you who are really sort of following the case very carefully, the Harvard case boiled down to, this is the claim that the process that Harvard was deploying had discriminated against Asian Americans. And it sort of reduced, as it often does, to these two different econometric models, and there was sort of this unexplained residual to the personal rating, and Harvard's explanation is like 0.12. It was very small. It was a very small coefficient, but Harvard's explanation was, the personal rating is sort of negative for Asians because the inputs, primarily teacher recommendations and secondary school reports, have exhibited some skew here, and so it's not really our fault. And the trial judge essentially said, that's good enough, and the plaintiffs have the burden of proof here, and so we're going to go there. One thing interesting about the UNC case was Ryan Park, the Solicitor General at UNC, the Asian American equivalent to personal ratings was actually higher than average, right? Does that have something to do with the sort of self-selection of the people who apply to the Asian Americans who apply to the University of North Carolina and so forth? So it's interesting. I mean, and I just use that as an example of something that cuts differently across those two cases, right? So there's a few other things like that, but my general inclination is to think that they're going to move as one, and that they're not going to, obviously one's public and one's private. I mean, I don't think that they're going to sort of split the two using some of these very interesting differences between the two cases.
Anything else?